Good afternoon and welcome. This is our webinar, Effectively Assisting Your Aging Parents with Their Financial Affairs. I'm Rob Fairley, President and CEO of the United Methodist Foundation of Louisiana. The foundation works with churches, helping them manage their money, loaning them money when they need, and helping them encourage generosity throughout their churches. However, our primary purpose, if you turn to the rule book, the Book of Discipline in the Methodist Church, is we are to educate people about and encourage the practice of planned giving. Now, planned giving is how each one of us can help our family and others with our stuff after we're no longer here to be with our stuff. You know, this virus has reminded all of us that our lifetimes are finite. While anyone can catch the virus, it appears particularly dangerous for the elderly. A thumbnail rule defining that term seems to be the age 65. Now, currently, 16% of our population is already age 65 or older. 10,000 more are turning 65 each and every day. 10 years from now, every baby boomer still alive will be 65 or older. This is a large portion of our population. This webinar is designed to help you, if you're in that category, or help you with your parents, understand important issues that you may face in your life or theirs, because as you do get older, as we all know, complex issues are harder for us to control, to understand, and to manage. So this webinar is being recorded and it will be available in 2 or 3 days on our website. If you have any questions as we go along, please enter them into the question and answer, the Q&A section or feature that you'll see, and we'll address them at the end of the presentation. So let's get started. First, let me tell you about our presenter. Rhonda Gabba is an estate planning and elder law attorney practicing in Covington, Louisiana on the North Shore. And she's helped hundreds of people through her seminars and through her writings, her articles, to protect their assets, to provide for their loved ones, and frankly, just to plan for life's contingencies with proper planning. So with no more to do, Rhonda, welcome, and it's all yours.
Thank you, Rob. All right, now I started my video and I'm going to be the first one to tell you all that technology and me have not usually gotten along. All right, here we go. I'm sharing my screen and it's coming and there it is. And Rob already said much of that about me, so I'm going to go to the next slide. Well, we're going to try to go to the next slide. All right, there we go. And my little clicker has been on pause. There we go. Excellent. So most of the time I do seminars live. So I'm standing up because I tried doing it sitting down and I just couldn't get my hands rolling. So usually some of these slides work better for live presentations because we thank you for coming and we lock the door so you can't leave. Today y'all can leave a little bit easier because you can click off, but I hope you don't. Rob and Kelly at first were a little surprised, I think, that my presentation was going to run possibly an hour and 10 minutes. But I hope we hold your attention because we're going to cover a lot. And that's why Rob said, for our questions later on, jot them down, because a lot of the questions I think you all may have now, we're going to answer as we go along. So this is a general estate planning seminar, if you will. It's going to be geared, of course, for our aging and elderly parents, but 90% of what we talk about is going to apply to us as well. It's just general estate planning is important for anyone, no matter what age. I'm going to try to go off of the slides a little bit and maybe take you down a road that are a little more important today and more important for our older parents. But one of the things, and Rob had hit something the other day, he said about 70% of folks don't have wills. And generally that's for a word that begins with P, and it's not probate. The word's procrastination. It's procrastination because we don't know what will happen if we don't have a will or some type of an estate plan in place. My goal for today or for the next hour is so that you're going to have so much knowledge that lack of knowledge is not going to be your problem. You're going to have too much. But this is great because this will give you the different roads to go down to find out a little bit more. At the end of the presentation, I think we have a slide that has my website, And I've got articles on there. I've got videos on there. You can, Google and find other things, but a lack of knowledge is not going to be the problem at the end of the hour. I'm going to be throwing at you today what we used to do was a 4-hour, what we called an elder law boot camp. And for the most part, we kept about 95% of the folks awake for the whole time. So that's a pretty good statistic. But what I'm not going to talk about today, and if you all like what I have to say, if Rob and Kelly are happy about it, maybe we can do some other seminars that go off on some other tangents that are extremely important for our older population, which is Medicaid planning. Everybody's afraid of what's going to happen if my parents or myself have to go into a nursing home. Special needs planning. I will tell you this, that is my favorite part of my practice. Probably a fourth of my practice is dedicated to special needs planning. So if any of you out there have special needs, children, grandchildren. So, we're going to do the basics today and hopefully, wet your whistle about some other things that you may want some more information about. So we're going to talk about trusts and what are fees, about what successions cost and things of that nature. And then at the end is when we'll take questions and answers, because like I said, you may think of some questions along the way. We're gonna answer them as we keep going. So that's what we say. Ground rules. This works a lot different when it's live because people are like, hey, I can control you, through the internet. So we'll wait till the end for our questions, and we'll start with saying, what is an estate? Our estate is everything we own, whether it's millions, whether it's not. Everybody has an estate. And our estate is important to us, whether our estate's worth $100,000 or whether our estate's worth $10 million. What we have to remember, and this is becoming bigger and bigger, depending on how old you are or how old your parents are, this may be a different figure. For most of us that are younger, and when I'm around the young folks, 54 doesn't seem young, but when we see people in here that are in their 90s and 100, every other week, I'm a baby. Most of us younger folks, our retirement plans are the biggest part of our estates, not necessarily what's going through our wills. And you're going to see in a minute, that's very important. Most of our IRAs, our 401ks are huge in comparison perhaps to our cash assets or our after-tax assets or our home, okay? Life insurance. The younger you are, generally the more life insurance you should have. If this young family like you see on your screen, I would hope that this gentleman would have a few $1 million, literally, of life insurance. Maybe term life insurance, it's very affordable, but think about the beneficiaries of that. And this is something I want to spend a little time on, because we see beneficiary designations go awry all the time. Just this year, I've probably done, a handful of successions, and we'll talk about what that is in a little while, probate, that I never had to do. It was because the folks had beneficiaries inaccurate. The beneficiary was somebody who had passed away. Long story short, many times when there is not a beneficiary chosen, the beneficiary is the estate. And if the beneficiary is the estate, we've got to open the succession or bring it through the succession. So what's going to be of paramount importance for you all that have beneficiary-driven assets? And what are they? Life insurance, IRAs, 401ks, 403bs, annuities. All of those things have beneficiary designations. Make sure you have a primary beneficiary name. And that's where most of us are right on the money. We name a primary, we name our spouse. But make sure you have a contingent, which is a secondary beneficiary. In case what? In case that primary beneficiary might predecease you, in case you and that primary beneficiary may perish together, okay? So for most folks, that primary beneficiary will be our spouse, if we're still married, and that contingent beneficiary will be our children. Also look for something called per stirpes. You see that in your third bullet point. Per stirpes is Latin, means down the branch. And what I found, in fact, I just did one yesterday, most of the brokerage houses today, for their change of beneficiary forms for their IRAs, they have a per stirpes box for you to check. And what it simply means is, if you're, let's just say the primary beneficiaries to make it easy. Let's say I'm already a widow and I've redone my beneficiary forms for my IRA, and I've named as my beneficiaries my 2 children equally. I've named John and I've named Susan as my 50% beneficiaries. And if I check that per stirpes box and me and my daughter Susan perish together, okay, and Susan has children, Susan's 50% of that IRA is going to go down that lineal line, down that branch to her children. And then 50% is going to go to my son, John. If you have not chosen a per stirpes box or written it in, because sometimes the beneficiary forms don't have a per stirpes box, and many of them allow us to write it in, okay? If I didn't have per stirpes chosen for Susan, and Susan and I perish together, 100% of my IRA now paid to my son, John. Nothing went to my daughter Susan's children, which is what most of us and most of our parents want. If we would predecease them, if we would die with them, most of the time, they want our share to go down our lineal line to our children, not to our siblings, not to their other children, okay? And that last box I have on there, watch for a change of ownership. Long story short, and we'll get to it more later, the federal estate tax exemption amount is now huge. We'll get to it in some other slides, but just to wet your whistle, it's 11.5 million, okay? Years ago, when I first started practicing law, it was only 600,000. And sometimes these term life insurance policies that these younger people had that had cash value of 0 actually caused them to have an estate tax problem. So we talked about that in an incident of ownership, but that's another seminar. I'm happy to do it. But beneficiary designation is so important right now because so many things allow for beneficiary designations. One thing I would like to hit on, I don't have another slide, but this is important, and it's an aside, but it's an important aside. Louisiana, as far as I'm told by Kelly and Rob, all of you all listening today or in Louisiana, okay? We do not recognize a type of payment called TOD, transfer on death. It only applies to your brokerage accounts. And actually, we did have a case a few months ago with a Vanguard issue, but that is more the exception than the norm, okay? TOD does not work in Louisiana. Many of us have advisors that are in Louisiana and don't know that, and that's dangerous as heck, okay? But a lot of times we may have an advisor that is from out of state. I don't blame the North Carolina advisor for not knowing that Louisiana does not offer or acknowledge a TOD designation. So be careful. Do not rely on a TOD designation if you have any in place. Do not rely on an account that says joint tenancy with rights of survivorship. We don't have that either. If you are a husband and wife and you have a joint after-tax brokerage account, the title should read husband and wife community property, not tenants in common, not joint tenants with the right of survivorship, not TOD. It should read community property. I'm off on an aside with that because we've had a change in our law about 2 years ago, and it seems like 99% of the industry does not have a clue about that. If it says community property on your brokerage account and one of you dies first, the dead person's half is going to get frozen until we can open the succession, but the alive person's half is not frozen. That's the change, because 2 years ago, before this change was in, it was August of 2018, the whole dead blasted account got frozen. Now, as long as it's titled as community property, not going to get frozen. So that's an aside, but very, very important for you, for your parents, for anyone that lives in Louisiana as a married couple. So we do not want to forget all of our stuff. Let me talk to you about the stuff for a minute. I am an estate planning attorney. I do successions. I do not do litigation, okay? but let me help you and your parents and your siblings and you hopefully stay out of litigation. That stuff on your screen is what the people fight over. It's not the $1 million brokerage account. You know why? Because cash can be split. You know what you can't split? That piano. You know what you can't split? Mama's ring, a computer. So if you have particular sentimental items that you know you want to go to specific people, let's spell that out. Either in a separate writing, preferably, within the will if this is something highly contestable, because these are the things that folks fight over. And what we don't realize is if your will says everything goes equally to my 4 children, it means the couch goes to the 4 children and the TV goes to the 4 children. And although you won't think anybody will fight about anything, trust me, they will. Okay, so most of us need an estate plan. Now, when I say an estate plan, it can be as simple as a simple will. Why? So that our assets go where we want. In a few more slides, I'm going to show you exactly where your assets go if you don't have a will. You may say, Rhonda, how do you know? Because the law tells me, okay? So when I talk about a simple estate plan, when we're finished with today, okay, if there's anything we've talked about that you're just not going to be able to sleep tonight, you might want to do what we call an holographic will. It's spelled O-L-O-G-R-A-P-H-I-C, not with an H. With an H, holographic wills are in other states. But this is our law on an holographic will. Very simple. Must be entirely in your own handwriting. Anything that's not written in your handwriting, it's like we just put white out on it because the judge can't even look at it, okay? So it has to be entirely in your own handwriting. And it basically has to be signed at the end. That's it. You want to date it? Our law actually says as long as the date is ascertainable. There's a great way to ascertain a date. You write the date out. Don't do numerical dates, because if you did 3-4-20, somebody in the military might presume that to be April 3rd, because they do number months. So just write out, August 3rd, 2020. I, Rhonda Gabb, make this will. Why do you want to say that? Because it's got to be clear that it's your will. Some people really have wills and they will say, to whom it may concern. I'm making a joke. Dear God, it needs to be clear that it's your will. And what better way to do it is to say, I, Rhonda Gabb, make this last will. I leave my entire estate to my daughter, Susan, and I sign it. We don't need witnesses. You certainly don't need a notary. And as a lawyer, of course, I want to tell you, it's far better and safer to have a will done, by a lawyer or by a notary. But in some circumstances, if an holographic will is far better than what intestacy is, and you're about to find out what intestacy is within the next 10 or 15 minutes, feel free, do an holographic will until the time comes perhaps that you can do a formal, what we call a notarial will. Now, relatives or friends, friends will never receive anything via intestacy. Your church will never receive anything via intestacy. It will only be relatives, and only of a certain degree that the law has already prescribed to say, this is who receives your estate without a will, okay? So now let's talk about forced heirship. And I know Rob told you a little bit earlier, and so did I. I have some articles posted on my Facebook page, on my web page. And this month's, it's for September, but I had to already write it to submit it. My September article for Slidell Magazine is actually on forced heirship this month, and I write about it time and again. But this is a misconception many people have, is that we no longer have forced heirship. And that's entirely untrue. Forced heirship has been limited, okay? In 1996 is when we had the huge sweeping changes of our law where we limited it. As an aside, I want to tell you all why I do what I do. My father died in 1983, okay? He was 60. And he was still a forced heir of my grandfather. My grandfather never went through the proper steps of disinheriting my dad. And long story short, my grandfather's succession was contested and litigated for 11 years. My father kept this, in the courts for 11 years. I'm saying my father died. My grandfather died in 1983. And at that point, my dad was around 50, then my daddy passed 10 years later. My dad kept this succession and the fighting going and going because before 1996, inheritance was clearly a right and not a gift, okay? So what we chose to do, I call this now limited forced heirship. Prior to 1996, it was unlimited. Why? All of your children were forced heirs, no matter how old they were, no matter their condition, except for some archaic reasons of which and why and how you could disinherit a child, okay? So the good news is we've limited it substantially, but we still have it. So now you have forced heirs if you have any children that are under the age of 24, or if you have any children that are disabled, and disabled to the extent that they are permanently unable to manage their estate, okay? Just because someone is receiving a disability check does not automatically mean that they're a forced heir. We need to plan for it. We need to plan for that claim. But just by virtue of them receiving a disability check does not necessarily mean that they rise to being a forced heir. But as I told you all earlier, I do a lot of special needs planning, and especially for Down syndrome folks. And what is the most wonderful thing is you see these Down syndrome children today, they're living to be 65 years old, okay? But a Down syndrome child, for the most part, is going to be determined to be a forced heir of their parent. So if you've got a 60-year-old Down syndrome child and an 80-year-old parent, yes, that 60-year-old, even though they're way over 24, is going to be the forced heir of their parent for the rest of their lives. Now, watch out for this, and I don't mean watch out for this, but when we have folks fill out our questionnaires, one of the things I'm going to ask is, do you have any special needs grandchildren? Why am I asking that? For this reason. Because if your child, who is the parent of your special needs grandchild, so let's say that Bobby has Down syndrome, he is your grandchild, and Bobby's father is John, that's your child, okay? If John would predecease you or die with you, your special needs grandchild, Bobby, just stepped into his daddy's shoes and became your forced heir. So we have to plan very delicately and deliberately for folks that have special needs children or special needs grandchildren. Most of the time what we're doing is we're usually creating special needs trusts. Why? Because most disabled, profoundly disabled folks or special needs folks are generally receiving some type of a government benefit that is an income and asset-based program, okay? So special needs trust are very important. And as I said, we actually have a whole seminar, we do based on that. Now, you may be asking, well, how much do I have to leave? And that's going to differ as well. The good news is, or you may not even think this is very good news, but you are always free to leave 50% of your estate to anybody you want. The forced portion will never exceed 50%, okay? The forced portion is 25% for one child, but that 25% will never be more than an intestate share. What we mean by an intestate share is if you happen to have 10 children, each child through intestacy would inherit 10%. Well, if only one of your 10 children was special needs, it wouldn't be fair to leave that one child 25%. It would be too much. So in that case, the forced portion, would be 10%, not 25%. So again, that does get kind of complicated, but I think it's something that you need to be aware of. So most of us do need some type of an estate plan. Also to leave our assets to those for when we want. And of course, when I'm doing a seminar is when I'll start coughing. So what we mean by that is, as we talked about just now, the disabled children. What if they're just minors? What if they have special needs like drug or alcohol addiction? This is going to be where we're going to create trusts for the children to perhaps hold the money forever until they reach a certain age, until a certain event. So this is going to be important in doing an estate plan as well. Lastly, we say handled by the person we want. What does that mean? It means if you know which one of your children you don't want handling your estate, if you don't have a will, that's the one that's going to fight the hardest to do it. It's just the way it is. So your will can also pick exactly who you want to be your executor, pardon me, to be your trustee. Because through intestacy, as you'll see in a minute, there really are no choices. It's, statutory things that are mandated about who gets what. Lastly, at the least cost, and we say that because even though creating estate plans are costly, we find in the long run, it generally saves, a lot of fighting, a lot of litigation, especially if things are done ahead of time, the right way, and addressed the way that we recommend, that, and we'll talk about that a little bit more, that your parents or you leave directions for the kids. Where are your assets? Leave that treasure map of where they are. Have copies of everything, because, a lot of times we meet with kids, and this is a great time for you to have these discussions with your parents. You can tell them, we don't need to know what you have now, but we need to know where to find it. Leave me a list. Leave me a binder. Leave me an envelope with copies of your latest statements. We recommend January every year, to put your December 31st statement somewhere, and let your kids, or if they were your parents, let me know where to find it for when you're gone, or if God forbid you become incapacitated, okay? So I did a really, really good article. It's one of my favorites that I believe I've done. And it says, leave a treasure map, not a treasure hunt. And that makes so much difference. And what we find, and I'm sure many of you find this with your parents, the older they are, they've been through times we can't imagine. Hopefully these times aren't coming again, but they've been through depression. They've been through, where money was tight and things were tight, and they're very secretive. They don't want, they don't want us to know what they have and where it is. So the best things that they can do is just leave you at least that map of where to go. So now we're going to talk about, succession and some trust law and a few things, and I'm going a little bit quicker now. So our case study is going to be Bill and Mary Jones. Married couple, worth about $700,000. Some of you are more, some of you are less. It's going to apply to everybody. So, widowed, divorced, married more than once. This is one of my favorite slides. There you go. Bill and Mary's family. They've got Susan, they've got John, and we always, laugh about this because, John may be the empathetic guy taking care of mom and dad. Susan may be off busy running companies and she doesn't ever call mom and dad. You just never know. So when I have my seminars and I can actually, bounce back and forth with the crowd, I generally ask, what is the most fun planning option that we have? And, usually somebody will yell out the right answer, which is what? We can spend it all. I live in St. Tammany Parish. And this, I haven't seen it in years, but you've seen these. There's a RV, that had multiple air-conditioned units. It was, I had probably a $500,000 RV. And the bumper sticker said on the back, what? We're spending our kids' inheritance. I love that one. Well, it was funny, and I never did have my phone to be able to take a picture. The same day I saw that RV by the Madisonville Bridge or whatever, a little bit later, I saw this old, heck, I don't remember what kind of car it was, Plymouth Duster or something, and the muffler was on with a hanger that was twisted. It was Bondo, and the bumper sticker on the back of that one said, "This is our kids' inheritance." And I've laughed about it to this day and said I wanted to do a split screen, proper planning. But my point is, unless you spend it all and you're going to have pretty good timing, what's going to happen is when you're gone, you're going to die intestate if you don't have a will. And as we know, the majority of folks are probably going to die intestate. And then the state is going to say, hey, don't worry about forced heirship claims. Don't worry about any of these claims. We're going to tell you, we're going to pick up the civil code, and statutorily, we're going to tell you where your assets go. And so now this is what we're going to want to spend some time on, because now this is the estate plan that most people have. So let's talk about community property for a minute. If you remember a little while ago, I said, ideally, how your brokerage account should be titled if you're a married couple, community property, okay? Community property is only for married people. So if you've never been married, you can't have community property. So the presumption under our law is the moment you get married, unless you've done a marriage contract, what we call it, prenup, okay? You embrace this community property regime. And what that means is every dollar that comes into the estate is presumed to be community property. It's an undivided 50-50 ball of half belongs to the husband, half belongs to the wife, okay? It's an undivided share, meaning you can't go into a community property home and put the piece of tape down the middle of the kitchen and say, well, you own that half and you own that half. If you go in the backyard, every handful of dirt you pull out of the yard is owned 50-50. That's what we mean by, undivided. There's no clear, bifurcation of it. So in Bill and Mary's case, if Bill died first, and sorry guys, but that's generally what happens. You guys die before us and we live another 7 years in grief. So Bill dies first. His two kids we saw were Susan and John. So Bill's half, and this is where I have my board here and I'm waiting if we do some questions later. But remember, if Bill and Mary own the house, okay, Mary already owns her half. Bill already owns his half. I don't know if you could see well what I'm drawing unless you do that split screen, okay? But here's Bill and here's Mary. But when we talk about a succession, I'm talking about Bill's 100% of what Bill owns. So this 100% of what Bill owns is his 50% of the house, okay? So everything that Bill owns goes equally to the children. Mary does not inherit any of Bill's share. You heard me right. The surviving spouse does not inherit anything from Bill's share if they have children, okay? My example, they do. We've got John and Susan, or Bill's two children, okay? So John and Susan get what's called the naked ownership. And I'm going to go forward to a screen and I'm going to come back, okay? I'm going to go back to the other. I learned this in law school, but I also learned this way before law school when I was a realtor, okay? And they teach you this. This is what we call full ownership. We call it a bundle of rights. And if you and your husband or you and your wife own your own home in full ownership, you own these three sticks. That's how we were taught. There are three sticks. That first stick is what is called usus. And these are all Latin, okay? Usus means what? Just like it sounds, use, usage, enjoyment. The second stick is called fructus, okay? But fructus meaning what? Fruits, revenue, income. The third stick is what we call abusus, and that's the power to alienate, encumber, to sell. And in Louisiana, abusus is called naked ownership. I don't know why, it just is, okay? So you have usus, fructus, and abusus. Now you see that crazy word that I haven't said yet, okay? But you see where it came from. And I always make a joke. I said, if you're not from Louisiana, please don't think I'm cursing, okay? Usufruct is usus and fructus together. And then the other one is the naked ownership, okay, which is the abusus. So now let's go back. So what does Mary, as the surviving spouse, get? She gets usufruct. She doesn't inherit anything because remember, the abusus that John and Susan got, well, that's the ownership. They inherited, John and Susan inherited the ownership. Mary gets usufruct over it. So if you almost want to look at this, Mary, she owns her half, but Mary then has usufruct, okay, over Bill's half. So what can Mary do as the usufructuary, that's really what she's called, over Bill's half? Can she rent it? Sure. Why? What does rent bring in? Fructus. Can she use it? Can she live there? Yeah. What can Mary not do? She can't sell it. She can't sell it. She can't mortgage it. She would need the children's permission to sell. Okay, now remember, she owns her half. So now we're saying, how and when does the usufruct terminate? So look at the fourth bullet point. It terminates at remarriage. Terminates at death, of course, but it could terminate earlier if Mary remarried. So could this happen? Now again, if you all were in my audience and I was looking at all of you, I would ask, has anybody around here heard where their friend remarried and their children, their own children, forced them to sell the house? Yes, yes. Some of you out here probably going, oh yeah. Because why? Mary's usufruct terminates upon remarriage. Now, the kids can't kick her out. Why? Because she already owns her half. She's not trespassing, but she now doesn't own this half. And under Louisiana law, as I'm sure most states' laws are, we are never forced to co-own something with someone, okay? Now, you'd have to go to court to force the sale, but, so Mary remarries, she's got to ask the kids to be able to sell the house. And if we sell the house then for, let's say, $200,000, the title company says to Mary, well, here's your check for $100. But the title company now says, well, kids, you each get $50. And the kids will say, well, do we have to give it to mom? No, no, because why? Mary's usufruct terminated at remarriage. Even if Mary didn't remarry, she still needs to ask the kids permission to sell. And this is where we see often, and I used to be a title attorney, I've owned 3 different title companies. You will see children hold their signature hostage to say, well, we'll sign to sell so that mama can get her half, but in order for us to show up to sign, we want our half, okay? So this is a problem in and of itself when your children are majors. What do we mean by majors? They're 18 or older. 18 is the age of majority, okay? In Louisiana, it's 18. What if your kids are minors? Remember that scream several screens ago? We had the young guy with the young kids. What if he died? His children still inherit his half, but now they're 7, 8, and 11. Now his wife needs to refinance or sell the house because you know what? He let his life insurance lapse, okay? So now she's got to sell the house to have money. How do you get 3 minor children's permission to sell? She's got to go to court. Money. So don't freak out. This is intestacy, but my point is, if you don't like it, I mean, you can change it. Some of you may be fine with this, especially, you know, if you're single. Now, let me say this. If you have community property and you have no kids, it automatically, through intestacy, goes to the surviving spouse. So I'm changing my fact pattern. If Bill and Mary had no children and Bill died, community property would all go to Mary. If Mary died, would all. So community property will go to the surviving spouse when there is no lineal line, okay? And when I mean lineal line, meaning if they only had one child, Stephen, and Stephen had a child, Russell, and Stephen died, Russell's now the lineal heir, okay? We're talking about if there is no lineal line. So now let's talk about separate property, all right? Separate property follows a different devolution pattern than community property. And depending on what side of the fence you're on, it could be better or it could be worse, okay? So separate property, and I remember this like it was yesterday. It was probably 1999, maybe 2000. I'm doing a seminar. Used to be the hotel, and if any of y'all from around here, Metairie, that was where the plane was, okay? And I was doing a seminar at a hotel. And as I got to this slide, I saw a lady in the back just go gray, okay? Because she, and giving you her fact pattern now, she and her husband had been married 40-something years, but the home that they lived in was her husband's separate property. It was, given to him from his parents. It was completely paid for when they got married. So my point is, the ownership was never contested. It never had an inkling of community property dust on it. It was always separate and peripheral property of the husband. Yet he and the wife lived there and raised their 4 children there for 45 years. But it was clearly and unequivocally his separate property. What this slide means and what intestacy means is, if that were Bill and he died, Mary doesn't even get usufruct over the separate property. It goes directly in full and complete ownership to the kids. Now there is your circumstance where the kids could kick mama out. Ain't no forcing the sale. Mama doesn't own anything. Mama doesn't have any rights. She literally is a trespasser from the moment of daddy's death. So after the seminar, let's just say we had a mini consult, and I think I did a will for them in 48 hours. But anyway, so now let's talk about separate property if there is no children, okay? Or children or lineal down. Because again, if you have a child and that child has predeceased you, we call it representation. That's that persterpes, meaning the grandchild steps into the shoes of their deceased parent. Your grandchild steps up to basically be like a child for inheritance purposes. But what if there are no children? Your surviving spouse still doesn't get it. We've got going to the brothers and sisters, the siblings, naked ownership. Your parents, if you had any, would get usufruct, okay? If you had no parents, no siblings, and mind you, no nephews and nieces, okay? Meaning you didn't have any siblings. Then and only then would your surviving spouse inherit your separate property. So you're with me? That's that last bullet point. No children, no parents, no siblings, no children of siblings. Then the surviving spouse gets the separate property. So we see this very often because it is very common in perhaps a second marriage circumstance, you with me, that there is separate property, that maybe the married couple lives in what was the previous home of one of them. So this becomes very important, that you might want to do a will to minimally maybe give the surviving spouse a usufruct or a habitation, or give them 6 months or something, okay? So again, this is not meant to scare you. This is meant for you to see how our law works, going way back to slide 1, of knowing now how it works. So this is a circumstance for your own knowledge, for your parents' knowledge, if necessary. This is intestacy, and there's no, I did another article, and I like my titles, you will see. And the title is called Intestacy is Incontestable. You cannot contest intestacy. It's in the civil code. It's pre-written. It's in black and white. You can't go, well, I don't like that. There's nothing to contest about this because this is the way it is. So when we're talking about planning options now, we could do trust, wills. We talked about joint tenancy. Not a good option, okay? Now, you may own property, real estate, when I say property, real estate, in another state. So many of our clients have properties in Florida, Alabama, Mississippi. You absolutely positively can own real estate in another state by what is called joint tenancy with the right of survivorship. Why? Because the title is applicable to the state that it's in, okay? And what that means, because I think it's important that you know, if husband and wife own a piece of property in Diamond Head, Mississippi, and it's an acronym, JTWROS. And again, I don't know if you can see, I'll do this later when we get to questions, but it looks like that, JTWROS. That means joint tenancy with the right of survivorship. It's beautiful, it's simple, it's easy. They've tried to introduce it here in Louisiana. It never passes, and I doubt it ever will. Actually, I am on the Successions and Donations Committee of the state. And, you know, I remember the last meeting we had, and I'm thinking of the people sitting at that giant U-shaped table, and I'm telling you that it's not going to pass. But what it means is when one spouse dies, by virtue of the dead spouse's death certificate filed in the conveyance records of that county, the other spouse owns it in toto, 100%. No probate, no succession, no nothing. It is very easy. And I would probably recommend that if you do own property in another state, that's probably the way you want to own it, okay? So now we're kind of going on to an incapacity issue. And let's just say now, oh, I did put this slide in there. I guess I put it in the wrong spot. So again, we talked about this earlier. Community property is how you want those brokerage accounts titled, not tenants in common. There's that, not joint tenants with the right of survivorship, and not that TOD. Isn't that a shame? I just created this slide 2 days ago and forgot I dropped it in there, but I probably shouldn't tell you that. So as we go from there, Bill has a heart attack. But this is important now because we're talking about disability, okay? We all will die. It's just a definite. There is no if when I'm talking with folks about if I die. I'm making a joke because ladies, we're the ones that say when, and our gentlemen say if, and then we stare at them and they go, all right. So it's not an if, it's a when. But becoming disabled is the if. That is the if. Statistically, we have a much greater percent chance now of becoming disabled before we die, and the older we get, the higher the percent goes. But this is why everybody needs a power of attorney. We talked about intestacy, and let me digress for a minute about intestacy to not make it as horrible as as perhaps it sounded. If you are already a widow or divorced or single, and you have 2 kids, and you want everything to go equally to your 2 kids, that is what intestacy does. You don't need a will. Now, you need a will if you want to leave your grandson your car, or if you want to make sure Susan is your executor, or you want to be sure the Methodist Foundation inherits 10%. All of those things are reasons you need a will. But just by virtue of intestacy, it goes equally to your kids. There are many people who don't need wills, but everybody needs a power of attorney. Everybody. Why? There's no such thing as a statutory power of attorney. Bill and Mary can have been married for 65 years. It doesn't mean by virtue of how long they've been married that Mary can sign on behalf of Bill. It just doesn't happen that way. Here's a huge thing we see more and more now. IRAs, we talked about them a little while ago. What does the I in IRA stand for? Individual. What that means is Mary's name will never be on Bill's IRA, and Bill's name won't be on Mary's IRA. It means individual retirement account. So if Bill became incapacitated and he's got $500,000 in an IRA, and let me tell you, that is the best money to use first when we have to care for someone to pay sitters or assisted living or whatever. Why? Because we're pulling down taxable money and we're offsetting it, you know, with deductible money. So IRA money is the money we want to use. Mary cannot call up Bill's broker and go, hi, I'm Mary. I'm Bill's wife. You know that. Yes, Miss Mary, I know that. I need to pull $50,000 out to take care of Bill. The advisor's in a pickle. Miss Mary, I understand it, but the only one who can sign on behalf of this IRA is Bill. Do you have a power of attorney? She says yes. Then he says, oh, that's great. Send it to me. I'm going to run it up my legal chain at you know, whatever brokerage house I'm at. So this is where I'm saying this to you. This is becoming more and more common. Brokerage houses often will have their own power of attorney. Now, not sugarcoating it. It's written by their legal department totally to protect them, okay? But if your brokerage house does have their own power of attorney, as far as I know, Merrill Lynch has one, Wells Fargo has one, I think Morgan Stanley has one. Fill theirs out. In addition to mine or to whatever one you do with your own attorney, because that one you're going to see is general. But the reason why I want you to do Wells Fargo's too, or whoever it is because it's already on file with them. It's already pre-vetted by them. If Mary and Bill did these with their own IRAs, years ahead of time, now Bill is incompetent. Mary calls up the advisor and she says, I need you to send me $50,000 from Bill's IRA because I've got to pay sitters. He could go, Miss Mary, not a problem. POA is already on file. We know we can talk to you. Okay. So do that if your broker has one, right? But you want one anyway. We generally want them general, because what does it mean? It means you can cover anything and everything that may happen. You want them immediate. I just ran into this cyclical with a friend of mine, and long story short, her dad was my client. He moved to Mississippi. He redid the paperwork. The power of attorney we did was immediate. The power of attorney the other attorney in Mississippi did was only based upon his incapacity. It's very hard to prove someone's incapacity. You need doctor's certificates. Doctors don't want to get in the middle of all of this. Doctors often see patients for 5 minutes and maybe they can fake it for 5 minutes. This is what I tell my clients as to why I prefer the powers of attorney that we do to be immediate. Do you trust who you've named? And if somebody goes for it to be immediate, and if somebody starts thinking, well, I'm like, if you've got to sit back and think about whether or not you trust this person you chose to be your power of attorney agent, if you're in a coma and you don't have a clue what they're doing, you trust them, but you don't trust them to be named it immediately, where if they act without your permission and you see it, you now see it, you can change it. The issue is you either trust them or you don't. You want it to be immediate, because when you need to use powers of attorney, you generally need to use them quickly, not taking months to have them turn on, okay? You want to appoint successor agents. I wish I could tell you, I don't see this all the time. You've got a married couple with powers of attorney. It's husband to wife, wife to husband. Great. But what happens if wife predeceases husband and he forgets, or he's already incompetent? Who's his agent now? Or she's already incompetent? Nobody. You want a couple of agents appointed as successors in case the agent you have appointed first predeceases you or becomes incapacitated before you. Because once someone is incapacitated, they can't do new legal documents. That's the whole point. And you also want to keep these powers of attorney updated. I recommend every 3 to 5 years, you go execute a new one. Why? Third parties, banks, oh God, love them, banks. You will go bring a power of attorney to a bank. There's one I want to say out loud, but I'm not, because I know I'm being taped and Lord knows where this is going to be shared, okay? And the banks will say, oh, this power of attorney's 2 years old or 3 years old, or at one point we really had 6 months, okay? You want to keep them updated to keep them fresh. Plus, let's be honest, if you're looking at that power of attorney once every 5 years, you may realize 5 years from now, level 3 is Uncle Ernie, who now thinks he's Napoleon. So you might want to remove him, okay? You want to have specific powers spelled out. Third parties love to say, well, only if we see that power in there will we allow you to do this, okay? So, oh, and I forgot to put that last bullet, but I did that one a long time ago. So if your broker has their own, do theirs. Powers of attorney or of paramount importance. I'll tell you what, if any of you out there or younger, and you've got young kids now going to college, your kids need a power of attorney, because why? Once they're 18, they're a major. You can't speak for them anymore. So, a lot of times we will do these for a lot of our clients' kids that are going off to college, where we do a relatively simple power of attorney that's for finances and healthcare as well, because they can't talk to you anymore. It doesn't matter if you're writing the check to, Notre Dame or Tulane or LSU. They'll take your check, but they're not going to talk to you. So, healthcare documents. We often like to do the healthcare power of attorney separate, and I'll tell you why. Because many times the agents are different. You might want Susan, your CPA daughter, to be your financial power of attorney, but you may want your son, John, who's the empathetic, or, maybe he's a nurse or a respiratory therapist or a doctor. You might want him to be your healthcare power of attorney. Many times the agents that are the healthcare powers of attorney after each other might be any of your children, okay? You also want to do living wills. That's the advanced directive. That is, literally the end of life, the pull the plug. HIPAA powers, that's the Health Insurance Portability and Accountability Act. Our healthcare powers of attorney have those powers spelled out. Let me say this, my tangent on those of us here attending this to know more for our aging parents. Living wills are very important, especially, right now in light of all the COVID. But we also have something called a lock post document, POST. Physician's order for scope of treatment is what I think the post stands for. If you are terminal, if I would become terminal, I have a living will, but I would then have my physician do a lock post for me. Hospice agencies have them. The lock post is a living will, if you will, but it's also signed by your physician. The medical industry, people always ask, oh, is a living will a DNR? No. You know what a real DNR is? It's a lock post. That is the true DNR, because your treating physician has signed off on your lock post. Now you can get them online, but when they first came out, they were goldenrod. They stayed on the top of your chart. In the hospital, they were supposed to be either taped on the door or at the foot of the bed, so that when the crash carts came in and saw this goldenrod lock post, they left, because a physician has already certified not to do anything. Okay, so that's just an aside. If any of your parents are on hospice or very ill, or just extremely elderly and have had this conversation with their own physician to say, look, I'm 101. When God's ready to take me, let him take me. Get that lock post done. You can Google it, or hopefully your physician or mom or dad's physician would be aware of that. DocuBank, real quick. Just like it's spelled. You could go to www.docubank.com. A great organization that we recommend. DocuBank is a scanning facility. What we send them are all your healthcare directives. No, not your will, not your financial power of attorney. We send them your living will. We send them your healthcare power of attorney, your emergency contact people's names and phone numbers, and your primary care doctor's information. And it looks like a little credit card you carry in your wallet if you're on the side of the road and paramedics are looking in your wallet, if you're at the Grand Canyon on vacation. This card allows 24/7 access to not only view, but print out those documents. So no matter where you are, your healthcare directives are always with you. Great, great company, great, great service. What time we've got here? Okay, we got 3 o'clock, so about 10 or 15 more minutes, I guess. So now, this is, I think, important to know so that we don't go there without those powers of attorney. If somebody becomes incompetent without a power of attorney, you have to do what we call in Louisiana an interdiction. And you basically have to go to court and have that person declared mentally incompetent by the court in front of a judge. Maybe you will be appointed as what is called their curator, okay? So you get letters of curatorship. But you can't do everything I just told you with the power of attorney through a curatorship. You need the court to approve what you're doing. So this is not something that we want to have to do. It is expensive, it is humiliating, and in all honesty, I also do a seminar called Alternatives to Interdiction. Number one with a bullet, the alternative to interdiction is a very good power of attorney, okay? And here you go, curators have to post a bond, you have to appoint an under curator, they have to be personally served with papers from the sheriff. I've been through quite a few, and you don't want this for yourself or your parents, but in any way, shape, or form. So now for the next 15 minutes, let's finish up. Let's talk about when somebody's now gone. What is a succession? Probate is what it's called in other states. In Louisiana, we call it a succession. People ask me all the time, what is it? It's changing title. That's what it is, okay? If you've got a dead person's name on the title to the house, well, you can't sell it. We've got to do what? We've got to get the dead person's name off of the title. What does it really mean? Probate means to prove. It means you're proving to the court by virtue of a will, if we have one, or by virtue of everything we just talked to. If that person dies intestate, we are proving to the court what? Heirship. If the person died without a will, we've got to prove to the court, who are the children? I could entertain you, regale you with stories for the next few hours of people that lie. We get a call in there. I found out my father's succession was done and I wasn't named. Well, did he have a will? No, he died intestate. Well, you would be an intestate heir. Yeah, if stepmother told the court about me, real things, okay? So probate is changing title. It's putting the proper person's name on the title replaced by who the dead person's name is. This is why, going back many, many slides, remember what avoids probate. Assets that have a beneficiary, life insurance, annuities, IRAs. So, sometimes when there are no other assets that would have to go through succession, the beauty is once you don't own Louisiana real estate anymore, you may be able to have a multi-million-dollar estate that doesn't have to go through probate, because maybe everything you have are bank accounts that allow a payable on death. POD is different than TOD. Maybe all you have is, annuities and like so probate is the assets that actually have to go through succession to change the title. So that's what probate is. It can be expensive, okay? What I would recommend to everybody across the state listening, watch out for lawyers that charge a percent fee. It's legal to do so, okay? But it's not a good idea. Why? What if you find an attorney that says, well, we charge 3%? And you go, well, sounds okay. But if I am doing a succession for someone that has a place we have here on the lakefront, Mandeville, okay, has $1 million house on the lakefront, or they have an $80,000 condo right out my window, I'm right next to a little condo complex, I promise you what I am doing and what my paralegal are doing for the succession is the exact same thing. She is typing a different property description, okay? So why would you want to pay $30,000 because the condo is worth $1 million, or pay, now I went and did math, what is that, 2,400, I guess if it's worth, 80,000. It should be based on the amount of work you're doing. How we do it, and that doesn't mean that, it's the right way, although my staff would say, did you just say what we're, I believe it's the best way to do it. We charge a flat fee for most of the successions we do that are not under an independent administration, okay? But if it's under an administration, meaning a succession that needs to be administered, an executor gets appointed, they got to pay bills and do all that, we charge an hourly fee, because you know what? If it's an independent administration, which means independently of the court, you have a savvy executor that can do a spreadsheet, it might be very inexpensive. Or you may be somebody who needs their hand held the whole way. You may have 10 people that keep calling, and that might be expensive. So just, be careful there. Generally, when it's an attorney that goes, we charge a flat blah, blah percent, I get a little uncomfortable with that. And reasonable compensation, this is for a lot of times we have folks that have property in other states. And sometimes probate fees in other states by law are a percent of the estate, meaning that is their law. California is one, okay? So let's keep going because I've only got a few more minutes and I want to talk about death taxes, because haven't we been having fun? So let's talk about death taxes. The number one call I think we get, people want to do a will so this is what we get. We want to do a will so the state doesn't get my money, all right? That's not an issue of, wills in and of themselves are tax neutral. all right? Look at what the death tax, and we have no state inheritance tax anymore. David Vitter, I think, in 2007, did the repeal for Louisiana. So Louisiana is coupled with the federal estate tax, but watch. Look, this was the old estate tax, okay? This was, you know, when I first started practicing in 99, I think it was 600,000. But look at this, y'all. Now our highest bracket is 40%. It's no longer 50%. And the quote unquote, it's a big long acronym, but I'll just call it the Trump Tax Act, which passed in 2018, brought that estate tax exemption amount way up. Look what it is now, y'all. $11,580,000. And that is per person. So when people call on the phone and they go, well, we really don't want our kids to have to pay any estate tax, I will say, are you worth more than $23 million? And they're like, are you kidding? I'm like, no, I'm not kidding. Now, it is supposed to sunset back at December 31st, 2025. So on January 1st of 2026, what we mean by sunset is it's going to go back to the $5 million figure indexed to inflation. But look what it was in 2017 indexed to inflation. It was already 5.5 million. So 5.5 million indexed to inflation for 2018, 19, 20, 1, 2, 3, 4, 5, 6. You're probably looking at it being, heck, I don't know, 6.5 million. And remember, that's a piece. So still, you really, kids are only going to have some issues if you're worth, you know, even when it sunsets, more than 12 million bucks. And I will tell you this, if you've got more than 12 million bucks, call me because we can do all kind of fancy stuff. So annual gift exclusion amount, $15,000 per head. Big misconception I hear from people. You can gift $15,000 to anyone you want. Your yard man, all right? It does not have to be a relation. Husband and wife can each gift $15,000. So let's just say you want to try to move some big money out of your estate. People used to want to do that because the estate tax exemption amount used to be $600,000. The highest bracket was 55%. So it made sense for every buck you could get out of your estate. Now your kids save 55 cents in tax. I'll be honest, we're doing much less big gifting now, okay? So the $15,000 per head, husband and wife, so Mary and Bill could give to Susan and her husband Larry if they wanted 60 grand. Why? 15 for Mary, you know, from Mary, 15 for Bill, for John, and for Susan. That works the same for grandkids, for whoever you name, all right? There's never going to be an estate tax at the first spouse's death with proper planning, all right? But not if the surviving spouse is not a U.S. citizen. You may say, why? We don't want Bill Gates' wife, Melinda, to be a Venezuelan citizen. He dies, he leaves her, you know, $500 million for free, and, you know, she runs back, you know, back home to wherever it is. So again, a lot of reasons why we plan, even if we're not worth millions. Second, plannings, you know, Medicare, we'll talk about that. We kind of, you know, play off the spousal issues, and really that should be, I guess, Medicaid, but I mean, I do Medicare planning as well. Special needs children, you know, control issues. Most of the time, our estate plan, we do a will, possibly a living trust. We do it with a financial power of attorney, a healthcare power of attorney, living wills, and the beneficiary planning has to match. I got a really good article on my Facebook page or web page that I did last month, which is called Matching Person Shoes. It's just amazing that people don't match the will to the beneficiary stuff. And, you know, generally it's an oversight or a mistake. So we talk about this. You want to avoid bargains when you purchase parachutes, brain surgery, fire extinguishers, and estate plans. Lots of people out there doing it really, really badly, and that's unfortunate. And so now it is 3:10, and there's our information. I don't know if they gave it to you, but there's my website. Well, there it is, RhondaMGab.com. My brother named me. There is no H in Rhonda, so if you put an H in Rhonda, you will get bounced back. And I'm done. So I am going to leave that up just another second if you want to write anything down. And then Rob told me to stop sharing. Boom. Okay. So I actually finished about 5 minutes ahead of time. So there we go. So any questions now? Hi, Rob.
Thanks, Rhonda. Welcome. Thank you. Just a couple questions so far. One was about wills done by notaries. Can you talk just briefly about that?
Well, is it more specific or just?
Is a will completed by a notary sufficient?
Well, absolutely. Remember, not all lawyers are notaries, and not all notaries are lawyers. So the will is actually called a notarial will. So it has to be done by a notary. So I was a notary before I was a lawyer. I teach I used to until the COVID. I teach a notarial prep course. In many cases, I would rather have a will done by a non-attorney notary who's taken the class to know how to do wills than an attorney notary who's just thinking they can do wills by virtue of being an attorney and therefore I know everything. So that's about all I can give you there. But it has to be a notary. So I think the issue is it because it's a non-attorney notary? You want a qualified notary, whether they're an attorney notary or a non-attorney notary. And there are many on each side of the fence.
As I understand it, if you are a licensed attorney here in Louisiana, you are automatically a notary. Is that correct?
No, you have to register with the Secretary of State, meaning you don't have, if you are a licensed attorney and you pass the bar, you are exempt from having to take the notarial exam, but you still have to go through all the Secretary of States to be appointed as a notary.
Well, we always recommend that folks work with attorneys. We do not prepare wills. We say, I think you just alluded to, every attorney can, I guess, has a wills 101 class, but you don't go to a podiatrist for brain surgery. We recommend you go to an attorney that specializes in this area. So with that in mind, and I know it's going to vary from one parish to another, do you have any ballpark ideas of what the cost would be for a will or a simple will and trust?
You know, it is. It's going to vary wildly. You know, if you go to anybody who are the specialists, like for instance, if you go to the Louisiana bar, it's LSBA, Louisiana State Bar Association, lsba.org. If you go on their website and look up estate planning specialists, they will list all of the estate planning specialists in the state. And I think any of the specialists are probably going to be in the range for a complete estate plan for a husband and wife couple, probably somewhere between $2,000 and $5,000. Okay, because we are boutique firms, we are specialists at what we do. Can you go find someone to do a will for $100 or $300? Absolutely. And I'm not going to say just because it was $300, it's bad, but it is amazing when we meet with folks, and we set my appointments at least for a 2-hour window, and people will get on the phone or the Zoom now and say, oh, it's simple. And an hour and a half later, we're still chatting and they go, wow, I never thought of all of those things. So that's what a specialist is going to do, you know, that most won't. So, you know, but they will vary wildly. They absolutely will. From a few $100 to a few thousand, that'd be
I
easy.
understand. Well, you know, $5,000 on $100,000 state's 5%. So on $1 million, it's really percentage-wise pretty small. And to have it done correctly where you're not worried about it seems to be like good stewardship.
And it is, and you know, you see on the back end, you know, most of the litigation that I've seen is really because they weren't well-drafted wills, and it left it either A, open to interpretation, or sometimes, to be honest with you, it was not done to, you know, to proper form, and the wills were invalidated. Yeah.
Good. I don't know that we have any other questions. Wait a minute. We do have more. If your will does not match your beneficiary on your 401k, IRA, or other retirement plan, which one will prevail?
Always the beneficiary designation.
And those are things you can just request a form. You can update it. You don't have to hire an attorney There's usually no cost involved,
Yeah.
so it's good to do it, pretty easy to do.
Absolutely. And then, you know, this is kind of an aside, but for the foundation, you know, what we often see or folks may come in chatting with us about charitable bequests. I'm always a bigger fan of having the charitable bequests be through the IRAs. And the reason is, if we ask you as the foundation, would you rather me leave you 100,000 from my will or from my IRA? You're going to say, I don't care, because either way, we don't pay any income tax, but the people do. So what I often see are very large bequests, or maybe the 10% from the will, when if we could reconfigure the plan to leave the charity through the taxable money, the children actually net more because of a proper plan in letting the taxable money, you know, go to the charities. And you know, we see that often, you know, and especially for, you know, for you all, sometimes beneficiary forms allow what is called a tertiary beneficiary, which is a third level. And this is where we often put the, you know, the charities in there, because sometimes they're in the will as the ultimate beneficiary, but we can put them in the beneficiary forms as well.
Well, I appreciate that you pointed out the fact that the state in its wisdom and statute has no automatic designation for the church.
Right.
If it goes through the state. We had a question about written copies of the presentation. We won't have written copies, but you can get a copy of this PowerPoint with the various slides. That's part of what will be available on our website in the next few days. Let me just remind you of that fact, that that's going to be coming, as well as a copy of the recording. Also mention to you that the foundation for several years has offered an estate planning course. Some of you are familiar with it probably. It's called It Is Different in Louisiana. And I don't know if y'all can see this very well. I don't know if you know Mark Fry. He heads up this estate planning stuff at Phelps Dunbar. And he makes sure that we're not breaking too many laws with the information that we put out there. It is free. It's kind of a 4-week course. You sign up for it, and we send you a fourth of it each time. I can tell you it doesn't probably have as many details as you just heard, because it's pretty brief, but nonetheless, it's kind of a good place to start. So thank you all for attending. Thank you, Rhonda, for helping us out. For any information you've heard today, this Different Louisiana course, or just for help with life income gifts that might produce income for you as a donor now and for beneficiaries later on, your foundation here does all of that. We do not charge any fees. We don't require some of it come to benefit our operational expenses. We are your foundation to help you make your charitable bequests or your charitable gifts. So if there's nothing further, let me thank everybody for being here. Wish you safety and God bless.